All right, everybody, welcome to Better Call Paul. On behalf of Trident Title, Performance Title and Escrow, and Synergy Title, we want to welcome in our attorney, Paul Krasker. Today, we do a live question and answer section, so if anybody on the call does have any questions, feel free to pop in and ask. If not, I do have a list of questions that were sent into us throughout the week here to get answered on here. So, Paul, if you don't have anything specific, we'll get these going and talk through them with you, and then we will let you go. All right, number one, joint tenancy versus tenancy by the entire. And the reason that this came up is we have a client that's doing a refi on their personal house, and they said when they bought the house 4 or 5 years ago as new construction, whoever they were using, the builder was using at that time, selected or suggested that they use one. And now when they're doing the refi, they were suggested to do another. Would one matter, or would you suggest one if the case is happy marriage, 2 kids, everything seems good family-wise, they're not worried about any family-related issues, they're just curious what makes the most sense for them? What would you suggest?
Okay, so I'll go through the differences between them. There are 3 that you're talking about. One is tenants in common, and that means that they each of their estates takes 50% when they both pass away. So if I'm married and my wife passes, I would own 50% and her heirs would own 50%. That may or may not be me, may be the children, it may be a prior relationship, and she has kids of her own. So that's where you see a lot of these tenants in common, where the wife and the husband intend that their kids from different marriages each share 50% of the estate. That's tenants in common. Tenancy by the entirety and joint tenants with rights of survivorship are the exact same thing. And they can also say it by saying husband and wife. So all 3 of those designations after the names mean the same thing, that there's survivorship between the 2 parties. The last person to live is the one who owns 100%. So if you have a husband and wife as joint tenants with rights of survivorship, and the wife passes away, the husband owns 100%. If you have a husband and wife as tenancy by their entireties, that just means it's a married couple, same exact thing. Wife passes away, husband gets 100%. If you have no designation there, but it says, husband and wife, comma, as husband and wife, that also means the same thing. So those are the big differences.
Is there anything that does it matter? Like if a client asks you which one should they write or which one should they do?
So if there's no issues in the marriage and it's money, it's being acquired during the marriage, then tenants by the entirety, or as husband and wife, or joint tenants with rights of survivorship, all 3 of those are the right designation.
Understood. Thank you. All right, next. Go ahead.
Brian, I just want to point out one more thing, and Paul, correct me if I'm wrong. And another major difference with that is that tenants in common requires probate, right, Paul? If it's not in a trust or anything, and it's tenants in common, it's going to have to go through probate, where if there's rights of survivorship, it's not going to have to go through probate, correct?
Correct, which is why I say if there's no issues in the marriage, do the survivorship path, because in my example, if wife passes away, you're going to have to probate her estate to pass that on to whomever her heirs are.
Awesome. Good stuff. All right, next. Do I need to do an appraisal contingency when I already have an FHA addendum? So as is contract, agent is representing the buyer. They're worried that it's not going to appraise. Do you suggest or require them to do an appraisal contingency addendum as well, or just use what's already in the contract and what's in the FHA addendum?
So if it's the FHA, that language in that addendum is stronger than the regular language in the regular contract. So I would say you don't need an appraisal rider.
Yep.
If you have the FHA rider. However, if you're just doing the standard financing provision in paragraph 8B of the standard FAR contracts, then and you're worried about it appraising out, then I would attach an appraisal contingency. And here's why. The language in the standard contract only says that it has to appraise sufficient for the financing. So for example, if you're getting a 50% loan to value and you've got $1 million property, as long as it appraises out at $700,000, you could still get your financing for $500,000. But you're going to be really disappointed to have bought a $700,000 property for $1 million. You'd have an out if you did an appraisal contingency based on the purchase price. You don't have an out based on standard language in paragraph 8B.
So that's a great point. So anything with a higher loan to value or an FHA, you're a little bit safer, but if it's lower loan to value, make sure you have it.
Right.
Awesome. Another one came in that was similar to that. Another one came in that was similar to that. When is an appraisal contingency addendum needed with an as-is contract? Only if financing. So you covered that. If I have an as-is contract with one set of e-signatures and one set of ink signatures, will that be a problem? And it's for the same side. So this instance, I know the deal. There was a seller or two sellers. They were not married, not a couple. One did not have email. One did. One of them had to be signed in ink. One of them had to be signed electronically. And they're worried, is there going to be issues somewhere down the line that there were two different kinds of signatures on the document?
Both are perfectly acceptable. Of course, the big issue that you're raising here is that you need to make sure that you combine those two and then deliver it to the buyers. Because if one party had to hand sign and they just send it back to the agents and the agents don't deliver it to the other side, there's no contract as of that time period.
Makes sense. What happens if once title commitment is given, still no HOA application is even made? So in this case, the agent that asked me was representing the seller about roughly a 35-day contract on an as-is contract. Title gave the title commitment with, I don't know, I think it was 7 or 8 days before there was actually going to be a closing. They call the buyer to say, hey, good news, we got title commitment. And they find out the buyer did not even make HOA application.
Yeah, so unfortunately, the HOA rider, depending on which one you have, has that silly thing where the seller has to initiate the approval process. So if the seller didn't initiate the HOA approval process by sending something to the HOA saying, here's a copy of the contract, here's the buyer's contact information, they should be reaching out to you shortly. There's nothing in the in there that gives a specific time period other than prior to closing. And it says that the buyer can get their deposit back if they use diligent effort to timely obtain the association approval. In that case, I would turn back and say, you didn't use diligent effort because you never applied.
Makes sense. Are there certain documents that are required for a short sale potential listing besides listing agreement and short sale addendum? So in this situation, the person got a lead that they think is going to be right on the borderline of being a short sale. When they're looking to get this thing listed, anything required besides listing documents and short sale addendum?
Yes, a ton of them. And Jewel Wiggum in our office handles the short sale negotiations. She's terrific. She hasn't lost a deal in a couple of years. So if she'll take on the short sale, I'd be 100% confident that it's going to get done. Remember that she needs 120 days, and she has her own package of information that she asked people to deliver to her. It's designed so that she's submitting a fully completed package up front and that nobody has to start piecemealing information to the bank. She also wants to remind you to remind your clients that it's very important every single month when you get your bank statements to just send them to Jewel. Don't wait for her to ask. She'll send them to the bank to update it, but the bank needs updated financial information and just keep sending it to us. Send your pay stubs, send your monthly bank statements so that we've got everything we need.
Do you suggest or require all of that to be done and in before the listing is taken, or is there a certain time frame where you want to see that in? Like, should this listing agent go take the listing, get it signed, and then get to work on that, or do you suggest getting this package attacked first?
I think that a good listing agent is going to have Jewel's packet with her at the listing appointment and is going to say, I have a team that does a few thousand short sales in South Florida already, knows what they're doing. Here's a package for you to start filling out. It's important that you start accumulating this information now so that we're not stressed out when the offer comes in. I'm going to do my great job as a realtor, but I need you to do your great job as a seller by providing me this information within the next 2 weeks so that when the offer comes in, we're ready to submit, and all we need to do is update a few documents over time.
Great, makes sense. Tying into that, what are you seeing happening on new short sale orders? Do you see the numbers going up? What is your prediction for months to come?
Yeah, I don't see it going up right now because of the deferral and because of the limitation or the perceived limitation that you can't file a foreclosure action now. So everybody thinks that the governor stopped all litigation until end of July. That's not the case. We're seeing new foreclosures being filed. The only thing that the governor stopped is writs of possession and actual sales. But people are moving forward through the system very quickly to get to that period of time so that at the end of July and into August, there are going to be a ton of sales of record. What I think for the future, I think that there are a lot of people who aren't employed right now, and I think that it's going to be tougher when they come back because some of those jobs won't be available anymore. Other jobs won't be available. People are just trying to get their feet under them. Some people, after they get done with the PPP money at the end of this month, are going to lay off staff. So even people who are employed now are going to be unemployed 30 days from now. And so I think that's going to cause people to look at their finances, to look at their homes. We're getting a lot of people who we got mortgage modifications for 9-10 years ago coming back to us now and saying, this is stupid. I haven't got much more equity. I've got this huge deficiency balance sitting on the back end that I'm going to have to pay someday. And I have to put on a new roof now. And I'm not spending another $40,000 on a house that's still upside down. That's where I think you're going to get all these short sales coming in.
Makes sense. How do you feel that the customers are understanding their position with the lenders and the banks, or do you think it's still kind of, they made a decision because they were sort of pushed to or felt like they had to and don't totally understand it?
Decisions from years ago or decisions?
No, from like the last 90 days, like when they did do the, deferral or chose to not pay. Do you feel that they understand what's going to happen in, July and onward or no?
Okay, good. So I believe that the banks are doing the right thing with this deferral. I think almost all of the banks are going to just add payments onto the back end. So if you missed 3 payments now and your mortgage was going to expire in 2035, they're just going to add 3 payments on the back end at 2035.
Got it.
And if that's the case, then everybody's going to be happy. Everybody's going to be happy that they took the deferral and life is just going to move on. That's my hope.
All right, 3 more. Are there any pitfalls or issues that come up with doing title that you see on a refi when the home was purchased somewhat recently? So this example, it's someone doing a personal refi. They bought the home new construction, and now that they're in real estate, they're starting to kind of feel like they overpaid for the house because the upgrades, way loaded them up. They got through appraisal, but they're thinking that's because it was the builder's lender, and now they're going to do a refi because their personal financial situations have gotten better, and they want to knock it down to like a 15-year with a low rate. Anything that they should be worried about, or anything that you see coming up, or just with any refis in general, I guess.
Yeah, no, and point to reference here, not that it's a commercial for Trident Title, but if you're an agent that sends us referrals, we're going to give you a discount on the title for the refinance. And please remember to tell your lender to send the title to us to have it issued for the refinance. You're entitled to a reissue credit and a refinance lower rate if it's within 3 years, and we discount closing fees for agents who are forwarding us business. So keep us in mind for that.
That was actually kind of the next question too, about a flip, explaining the reissue credit in the instance of a flip. If they hold the property within 6 months, is it the same as that 3 years that you just said, or?
Yeah.
Can you just explain that too? Because I know a lot of people don't exactly get the reissue credit. Like, what are they actually getting credited for?
So here's what happens. Let's say you buy a property for $200,000 and you're selling it for $400,000. And you paid a premium of or the seller paid a premium for you at closing for $200,000. If you have that owner's policy, and we're going to go transfer that, property for $400,000, we can give you a reissue credit for the reissue rate of $200,000 because that's what your existing policy is for. So you basically pay it's probably about 20% off the policy. So it's a decent discount, and it's because title has been run in the recent future. We know that there's only a limited time period that we have to search the record, and we're only addressing certain risks that came up in that middle period of time.
Awesome.
We still have to get a new estoppel letter. We still have to get a new loan payoff. We still have to get a whole bunch of other things like a regular refinance, but the risks are just different.
Correct. All right, that's all I got. Anybody else? Any questions? Anything that anyone wants to add in? If so,
I do have a question. This is Evelyn.
go ahead.
The tenants in common that you described. So if it's a boyfriend, girlfriend, and they purchase a home, as I understand, so if one passes, the other one basically has control of the home, although they don't have 100% ownership. Is that correct?
No, it's actually worse. All they have is 50% ownership. They don't have control. 51% is control. They just own 50%. So if it's a boyfriend and girlfriend and the girlfriend doesn't have any children, that boyfriend is going to own the house with her parents or
Right.
whoever's still alive from those parents.
But can he then be forced to, like, or that just goes to court at that point? You know, like if they don't like each other, you know what I mean?
That's what happens. It goes to court. There's a partition action, and one party says, buy me out, or let's jointly sell. And that's what a judge would require. You go to mediation and everybody figures out what the fair market value is, and you get matching appraisers, and at the last minute before a judge is going to drop his gavel, the parties usually settle.
Okay. All right.
Awesome. Anybody else? Anything?
Paul, can you perhaps explain the relationship of life state and homestead relating to each other? I don't know if I'm making this clear.
I couldn't hear the first part. It's something in homestead?
Life estate, I think.
Life state and homestead. So a friend of mine or a client is buying someone's property, paying off her mortgage, basically buying it but giving her life estate. But
Okay.
she also said that if you do that, you can carry with the homestead. Who is going to benefit from the homestead?
Yeah.
What's the
So, so
relationship?
the homestead is available for people who own their home individually, who have owned their home through a revocable trust, and it's also valid for people who have a life estate. And so if you take title as a life estate and give the remainder to your kids, you have the ability to qualify for homestead.
I see. Okay, that makes sense.
Sure.
Awesome. Thank you. Anybody else, anything?
Going once, going
All
twice.
right, guys. If you have not already signed up for Monday, we are doing a class about 50 leads in 30 days, how to generate 50 leads in 30 days, all from the comfort of your home without having to pick up the phone. So for those of you that are not phone callers or don't want to be phone callers, this is for you, Monday at 11. Thank you to Paul, as always, for his time, his opinions, and everything on this. And for anybody who wants to continue to support this and keep these going, send us some topics so we can start planning out some topics for July. And thank you to Trident Title, Performance Title, and Synergy Title for bringing us Mr. Paul Krasker. Thank you, sir.
Thanks, everybody.
All right, guys, have a great day.